Welcome to this video on the Bakke case, a landmark Supreme Court decision regarding affirmative action. Regents of the University of California versus Bakke in 1978 challenged UC Davis's special admissions program. Alan Bakke, a white applicant, was rejected while 16 out of 100 seats were reserved for minority applicants. Bakke argued this constituted unlawful racial discrimination. The UC Davis Medical School used a dual-track system, regular admissions and a special admissions track with 16 reserved seats for minority applicants. Bakke's academic scores exceeded those of many special program admittees. He sued, claiming a violation of the Equal Protection Clause. Bakke filed suit in the Yolo County Superior Court, which ruled the special program unconstitutional. After appeals to the California Supreme Court, which also struck down the program and ordered Bakke admitted, the Regents appealed to the U.S. Supreme Court. Bakke's theory was that the special admissions program was an illegal quota system that excluded him based on race. He argued that the Equal Protection Clause prohibits racial classifications by public institutions, especially when he was more qualified than many special program admittees. The Regents argued the program was necessary to remedy historic exclusion of minority students and that diversity in medical education served a compelling state interest. They asserted race was only one factor in a holistic process, and the program did not constitute a constitutional harm to Bakke. This video now focuses on the arguments and key witnesses presented during the trial level of the Bakke case. We will now review the background of the Bakke case and its journey through the courts. Alan Bakke, a highly qualified applicant, was rejected twice from UC Davis School of Medicine. He filed suit, arguing the 16-seat reserved quota violated the Equal Protection Clause. During discovery, a hard cap on white applicants was revealed, which was later cited as evidence of an illegal quota. The district court ruled the quota unconstitutional and ordered Bakke's admission. The case eventually went to the Supreme Court, which partially adopted the injunction against quotas but suggested race could be used as a quo plus factor. The main arguments focused on the individual rights of Bakke versus the state's interest in remedying past societal discrimination. Bakke's side argued that quotas amounted to discrimination and were not a compelling state interest. Next, we will review the key witnesses presented by Bakke's side. Alan Bakke, the plaintiff, testified about his high qualifications and the injustice of being rejected due to the reserved seats. He conveyed a sense of personal injury from being judged by race rather than merit. Dr. David S. Woolley, Dean of Student Affairs, described the admissions program's architecture. He argued the special admissions track was a parallel process for disadvantaged applicants and insisted it was a, quote, plus factor, not an exclusion, as no white applicant was barred from the general pool. Dr. Octavia Dorsey, a medical student admitted through the special program, gave powerful testimony about the barriers she overcame. Her success demonstrated that the program tapped into potential overlooked by standardized metrics. Dr. Thomas L. Stoddard, a UC Regent, framed the issue as the university's obligation to train doctors for all communities. He testified that excluding minorities undermined the public health mission of a state-funded medical school. We now turn to the arguments and witnesses presented by the Regents of the University of California. The Regents argued the program was a narrowly tailored remedy for historic exclusion and served the compelling state interest of creating a diverse classroom. They maintained that the number 16 was an aspirational benchmark, not a rigid quota, and represented a surgical intervention to correct misconduct. This image represents the witnesses who testified on behalf of the University of California. Dr. George Lowry, a black orthopedic surgeon and a special program graduate, testified that his presence provided essential services and cultural understanding to underserved patients. He argued diversity was a necessity, not a lower standard. Dr. David S. Woolley, Dean of Student Affairs, detailed the admissions process, defending the parallel tracks and the use of lower academic thresholds as a flexible measure to assess potential among disadvantaged applicants. Dr. Octavia Dorsey testified about her success, demonstrating that the program successfully identified talented students whose potential was masked by standardized tests. Her testimony supported the view that the program addressed societal inequality. Dr. Thomas L. Stoddard reiterated that the university had a sovereign mission to serve all citizens. He emphasized that training a diverse physician workforce was a state obligation for public health. The district court ruled in favor of Alan Bakke, finding the racial quota unconstitutional. It violated the Equal Protection Clause and Title VI, leading to an order for Bakke's admission. The California Supreme Court affirmed the lower court's ruling. It declared the special admissions program unconstitutional because the racial quota violated the 14th Amendment and maintained the order for Bakke's admission. The U.S. Supreme Court issued a fractured 5-4 ruling. It struck down the rigid racial quota system, but simultaneously allowed race to be considered as a, quote, plus factor in admissions. Ultimately, Bakke was ordered admitted. The Supreme Court majority found that fixed quotas were unconstitutional under the Equal Protection Clause and Title VI. However, they allowed race to be considered as one factor among many to promote diversity. Justice Powell's swing vote was critical. He rejected fixed quotas but allowed race as a, quote, plus factor. His controlling opinion established the precedent that diversity in education is a compelling state interest. The Supreme Court dissent supported the use of rigid racial quotas to remedy past discrimination, arguing that respecting the university's judgment on this matter was essential to achieving diversity. The Bakke decision struck down fixed racial quotas, but affirmed that race can be a factor in university admissions. It established diversity in education as a compelling interest, solidifying the, quote, plus factor approach. Thank you for watching this video on the Regents of the University of California versus Bakke case.